Hello friends, this is the third video of our channel. We were seeing about section 41 of the Criminal Procedure Code, chapter 5, arrest of persons. In the last two videos, we saw them elaborately. In this section, we are going to see about section 41A. As per section 41, if a police officer comes to a conclusion that he may not arrest a person without warrant, applying his mind, what is the reason he is not going to arrest? Might be that person is not going to tamper the investigation. He is not a person of such a big character, such a bad character. And the offense that he is suspected to be done, whose punishment will not be more than 7 years. These reasons the police officer may keep in mind and he may not arrest that person. If he is not arresting that person, what he will do? He will call that person for inquiry. That is told in the section that we are going to see today. Section 41A, notice of appearance before police officer. A police officer who has already applied his mind and he has come to the conclusion that he is not going to arrest such a person without warrant, he will call that person for inquiry through notice. Who is that person? Against whom a credible information has been received, against whom a reasonable suspicion is there that he might have committed a cognizable offense, or a reasonable complaint has been made against that person. The police officer, through writing, he will be issuing a notice to that person that for such and such reason, such and such matter, he has to come before the police officer. After receiving the notice, such person, he will be having the knowledge why he is called by the station house officer for inquiry. After getting the notice, his duty is to attend the inquiry. He has to know that already an advantage has been exercised on him, that he has not been arrested. The procedure says that it is the duty of the person to comply with the terms of such notice. In the notice, it will be clearly mentioned for what reasons he is wanted by police officer for inquiry. If the person is attending the inquiry, he is complying with the terms and conditions of the notice. If he is going for the inquiry regularly, that person will not be arrested. But even then, if the police officer wants to arrest him, in spite of his regularity in attending the inquiry, he will record the reasons why he is going to arrest such person. If the person is not complying by the said notice, he is not receiving the notice, or he is not, after receiving the notice, he is not coming for inquiry, or else he is not, he is not ready to reveal his identity, such police officer can arrest that person, but after getting such order from a competent court. Knowing the knowledge of the notice, that person is not coming for inquiry, then the police officer, he might go to the magistrate or the competent court nearby to get such order, and then he can arrest him immediately. So these are the provisions of this section. In the next video, we will see about section 41B, procedure of arrest and duties of officer making arrest. Thanks for watching patiently. Please subscribe and get connected. Thank you.